How to defend dangerous driving charges in Ontario. Our lawyers have defended dangerous driving charges in all corners of the province and often appear in courts across the GTA in addition to the Toronto courthouses including Newmarket, Oshawa, Brampton, and Milton. What is dangerous driving? Section 320.13(1) of the Criminal Code of Canada reads that one commits the offence of dangerous driving by operating a conveyance, such as a motor vehicle, a vessel, an aircraft or railway equipment, in a manner that, having regard to all of the circumstances, is dangerous to the public. These considerations including the nature, condition and use of the place at which the motor vehicle is being operated and the amount of traffic at the time is, or might reasonably be expected to be, at that place. How is dangerous driving determined? Determining whether someone has committed the offence of dangerous driving is done by looking at the manner in which a motor vehicle was operated as opposed to the consequences of the driving. A court cannot conclude from the consequences alone, including a death or a collision, that the vehicle must have been operated in a dangerous manner. The nature of the driving must be established independently from the consequences. What standard is used to assess whether the vehicle was driven dangerously? Dangerous driving is assessed by examining whether the accused conduct, viewed objectively using the standard of the reasonable person, amounted to a marked departure from the standard of care that a reasonable person would observe in the accused circumstances. The prosecutor need not prove that the driver intended to drive dangerously. Rather, the court assesses the dangerous conduct against the standard expected of a reasonably prudent driver, regardless of the driver's intention. If the prosecutor can prove that the driving was a marked departure from how the reasonably prudent driver would have driven in the circumstances, the fault element of the offence will have been established. How is the term dangerous defined by the court? The requirement that the vehicle be operated in a manner dangerous to the public involves driving that is perilous, hazardous or unsafe. The word dangerous is defined in Black's Law Dictionary, 6th edition to mean attended with risk, perilous, hazardous, unsafe. Can speeding alone amount to dangerous driving? Excessive speed, depending on the context in which it occurs, can endanger the lives or safety of the public and amount to a marked departure from the standard of care of a prudent driver so as to support a conviction for dangerous driving. The determination of liability based on evidence of excessive speed also has to take into consideration the speed at which other vehicles on the highway are driving, as well as the speed at which vehicles may be safely driven on the highway. Consideration has to be given to the actual speed, the accused ability to maintain control over his or her vehicle, and the accused ability to reduce his or her speed to react to an unexpected occurrence or to avoid an accident. Consideration also has to be given to the nature of the roadway and place where the driving occurred, the distance over which the accused maintained the high speed, whether the accused was keeping a lookout compatible with operation of the vehicle at a high speed, and the entire driving pattern. Can impairment by drugs or alcohol amount to a defense to dangerous driving? It is not a defense to claim that the dangerous driving at the time of the offense was not voluntary or intentional by virtue of a person's intentional drug or alcohol consumption. A person's voluntary consumption of drugs and/or alcohol under circumstances in which he knew or ought to have known that his ability to drive might thereby be impaired is sufficient to support a conviction for dangerous driving. Can the involuntary consumption of drugs/alcohol amount to a defense to dangerous driving? Involuntary or unintentional consumption of drugs and/or alcohol, which lead a person to drive in a dangerous manner, may operate to negate the fault element for dangerous driving. For example, if a person operates a vehicle in a dangerous manner after becoming unknowingly drugged at a bar, they may be acquitted of the dangerous driving if they were unaware of the potential side effects the drugs had on their ability to drive. What are other defenses to dangerous driving? Unexpected medical impairments such as seizures, hallucinations, or blackouts may also provide a person charged with dangerous driving with a defense. However, if the medical impairment was caused as a result of the driver's voluntary decision not to take medication for the pre-existing condition, his actions will not be excused by his medical conditions. The accused guilt would be grounded on the historical awareness that, because of a diagnosed condition, the accused could be a danger to the public while driving. What are the penalties for dangerous driving? A person found guilty of dangerous driving may serve a maximum penalty of up to 5 years in jail. The penalty is increased to a maximum penalty of either 10 or 14 years depending on whether the person is found guilty of dangerous driving causing bodily harm or dangerous driving causing death. Along with the potential of a significant period of incarceration, a person found guilty of dangerous driving will also lose their driver's license for a period of at least 1 year in Ontario. A judge may also impose a Canada-wide driving ban for anyone found guilty of dangerous driving. How can you appeal a conviction or sentence for dangerous driving? It is always possible to appeal a conviction or sentence for any charge including dangerous driving. In some instances, it is also possible to suspend the driving prohibition in order to get back a driver's license pending the outcome of one's appeal. Every case of dangerous driving is fact-specific and needs to be assessed on an individual basis. Personal circumstances and the other circumstances surrounding the driving are important considerations. Let us help you solve your criminal law-related problem. Call us at 416-297-7200 to schedule a consultation. Our lawyers are available to discuss your case at either our Toronto or Vaughan office locations. We can also accommodate virtual consultations using our web conferencing software.